Order in the court. The Supreme Court of Florida is now in session. The Honorable Chief Justice Charles T. Kennedy presiding.
The court will now take up the third case on today's docket, in re amendments to Florida Rule of Appellate Procedure 9.143. I'll recognize counsel for the petitioner, Mr. Upson.
May it please the court. My name is Keith Upson, and I appear this morning on behalf of the Appellate Court Rules Committee. Good morning. Thank you for allowing us to appear remotely. I had the honor of chairing the committee's criminal law subcommittee from the origin of this referral through the response to comments filed in June, in which we've proposed alternative language as to subsection C of our proposed new Rule 9143. And I believe the committee's response to comments does a fantastic job of concisely noting the challenges we faced, as well as memorializing for your consideration the majority and minority positions on many facets, including many, if not all, of the concerns that were also raised by the commenters to the proposed rule. The majority of the committee consistently concluded that the amendment's provision 16B, 6B, providing that victims have a right to be heard in any public proceeding involving pretrial or other release from any form of legal constraint, plea, sentencing, adjudication, or parole, and any proceeding during which a right of the victim is implicated, as well as 16B, 6G's right to be informed of all post-conviction processes and procedures, and to participate in such processes and procedures, must include appellate proceedings if those provisions by their plain language have any meaning at all. Now, perhaps atypically in a rules case, our response to comments expressly recognizes that if this court agrees with the commenters or with the majority position, or excuse me, the minority position from the committee, that the application of 16B6 to appellate proceedings is debatable or needs further judicial interpretation, the committee agrees that the adoption of an appellate rule would be premature at this time and should wait for this area of the law to be further developed. As we've proposed—
Let me ask you a question about that. If I look at this revised rule proposal, it doesn't really seem to presume that a right, or certainly what the scope of any right would be. It just says a victim seeking to invoke a right under Article 1, Section 16. And that this seems to be just more or less like a procedural framework for somebody to raise a right they think they might have. They seek to assert it. And then if there are arguments about whether they in fact have the right or not, then that can be hashed out in the context of that. Why would it be wrong to look at it that as the rule that the revised rule in that way? It's not really settling whether there's a right or not a right, but at least arguably there's a right. And if somebody seeks to assert it, we're recognizing that that's how they ought to do it.
Justice Kennedy, that's exactly what we're trying to do. We're trying, particularly in the first subsection, by referring back to the definition of victim as provided for in the amendment itself, subsection B, directing trial court clerks to include in the record on appeal those things that the victims may have filed at the trial court level. But with the proposed revision to C, we have tried to leave that interpretation of the limit and extent of such participation entirely with the judiciary. Having concluded among a majority of the full committee that appellate proceedings must, by the plain language of the amendment, be included. We then turn to trying to consider whether having no rule at this time is better than providing some guidance, or whether a more specific rule, as the subsection C we originally approved and proposed and submitted to this court, would be better than a general rule. And at great lengths, we discussed whether or not the general rule before the court today is better or worse than having no rule at all, because we removed even, and I can tell you anecdotally, you have some of the minutes of my subcommittee meetings, and I don't know that you have as appendices those where we tried to flesh out putting a time limit, because at the very least, if you're going to say a victim has a right to file, if you're going to say a victim needs to file a motion in the court in which it seeks to invoke a right that exists constitutionally, there ought to at least be some time frame on it. And we tried really hard to do that, but given the nature of the different proceedings on direct appeal, where there's a notice of appeal and a record, versus original proceedings where neither of those could be triggering events, we found it more unwieldy, and we instead recommended to the full committee, which in turn approved and which is now before you as that alternative subsection C, far more general, and I think as a practical matter, to provide an amendment-defined victim with the barest procedure by which they're on notice that if they want to avail themselves of a right under the amendment, they need to file something with the court in which the matter is pending, outlining the nature and scope of what they would like that participation to be.
Counsel, under C1, it provides that a victim may file a signed statement. Could that statement include items or things that are outside the record?
Justice Polson, I think that's the number one alarm bell concern from both comments and among members of the committee, myself included, because this is my practice. I almost exclusively represent criminal defendants on appeal and in original proceedings. And after I calmed down, which is not to say the commenters had or had any reason to, and they can certainly, the FPDA can certainly speak for themselves. I realize we've already got rules under which I could address that in a worst case scenario. We can move to respond if in an extraordinary circumstance, and only speaking for myself, it would have to be extraordinary for me to feel like I needed to respond. I've been fortunate to appear in all such courts, and I have confidence that my courts aren't going to be concerned with extra record material. Worst case, I could move to strike. I think we can acknowledge practitioners aren't bashful about availing themselves of motions to respond or strike should they feel it rose to the level necessary. But the majority of the committee didn't feel like, because one of the concerns raised by the FPDA is that this is going to throw the briefing schedule akimbo, and it's going to introduce victims brief and then a reply to the victims. I mean, and I'm paraphrasing the concern that's expressed.
Was there a consideration of maybe perhaps just giving like amicus status to victims as opposed to participating as a full party?
Well, and that's, I sense that's in some ways a loaded question, because
it's not intended to be.
Well, I mean, this court's already said, I believe in Butler last year. No, I'm confused. It was in Butler that this court already said that what the victim's rights under Section 16 are going to have to be subordinate if there's any conflict with the defendant's rights. But it was the first district in LT that said that this does not elevate the victim to party status, and we never considered that it did. So I want to be very clear and I know you're going to hear from the FPDA that as a matter of fact, if we allow them participate to the level originally proposed in C1, they'll be de facto party status, to which we continue to disagree. There was, I do recall, and again, anecdotally, Justice Polson, some discussion in caution that I think we did briefly consider procedure similar to the amicus procedure. But as I sit here before you today, I don't recall why that fairly quickly died on the vine. I think the most likely explanation, given the overall universe of the conversations and the things we've grappled with, our concern was that we not create things beyond the plain language of the amendment itself. And I think our concern probably would have been that would have been above and beyond what the amendment contemplated or called for, and therefore not a proper procedural rule. It only took me 5 minutes to get to the answer to your question, Justice Polson.
If amicus status is required, let's say hypothetically, would it also require requires the appellate courts to permit victims and whoever else is entitled to it to hire counsel, to file amicus briefs, and to also be provided with time to argue before us?
Justice Labarge, I think that's exactly the concern, that we not hang too much substance on the skeleton and a procedural rule at this time. And where I'm sure the Public Defenders Association is going to tell you, because there probably already are attorneys marketing themselves as victims counsel.
Right. Mm-hmm.
And there will be such things filed. And this court, it's got to be on your radar that all these death penalty cases, that you're going to suddenly have counsel for victims now asking to avail themselves of this. But the courts are going to have to sort it out. We don't think there's anything about our rule that we've proposed that's mutually exclusive to that, or that oversteps the bounds of a simple procedure. It merely notifies amendment-defined victims, at least in the revised proposed subsection C, that they're going to need to ask the court, this is what I'd like to do. And then whichever court that is, if it's this court or the fifth or the second, they can then say how that court's going to handle it. And we also anticipate there will need to be revision to a 9143 should this court adopt it, as more substance is defined, as the limits and boundaries are defined in the judiciary.
In light of that, what is the argument for adopting 9.143 even as it is revised now?
It starts from the position that the majority of the full committee consistently reads 16B as giving defined victims the right to participate in appellate proceedings. If this court agrees, and they do have that right, we ultimately agreed having this general rule to be better, to provide some guidance to those defined victims on how to ask to avail themselves of those rights. We felt it was literally the minimal threshold procedural process by which they could request the determining body, the court in which they're in front of, I would like to avail myself of these rights that I now have.
Counsel, you're into your rebuttal time. I'm gonna give you a little extra time, but I just want you to be aware.
Thank you, Justice. With that, I'll leave that last minute.
All right, and I'll give you a couple extra minutes if you need it. So from opposing counsel.
Good morning, Your Honors. John Eddie Morrison from the Florida Public Defenders Association. I join Mr. Upson's gratitude for allowing us to do this via Zoom. I believe it's correct that Mr. Upson began his argument with a substantive argument as to whether or not what's generally referred to as Marsy's law applies in appellate proceedings. And I think that is absolutely correct. This is a substantive issue. To address Chief Justice Kennedy's first question, the amended proposal still says that the victim may file a motion, and then the question is not whether the victim may participate. The only question is the proposed scope of the victim's participation.
Well, what it says is a victim seeking to invoke a right under Article 1, Section 16 may file a motion setting forth the proposed scope. But that does not necessarily seem to me to presume the answer to the substantive question. It's just saying, okay, obviously, this is there's differences of opinion about whether any such motion as a matter of law substantively could be successful, whether there is any such right. But this is just saying, okay, if you want to seek to assert that there is such a right and to invoke it, then you just file a motion. Tell us about it. Now, I guess on the other hand, you can say, well, that's what people are going to do anyway, even without the rule. So it's just kind of it is a kind of bare bones thing that is maybe not much different than what would happen in the absence of a rule.
Yes, Your Honor.
That's an observation. Please respond.
Let me just game this through the way this would work in real life. Someone would file a motion, the victim would file a motion. Somebody will object, saying, no, there's no right under the Article 1, Section 16. And the response would be, but the Florida Supreme Court already said I may file a motion. That's the language of the rule. And the question then is the proposed scope of the victim's participation. Frankly, I think that's how every argument is going to go if this rule was to be adopted by the
court. I mean, it says seeking to invoke a right. I mean, I don't.
If Your Honor, the only language I can see that would possibly sort of get to the real issue is the victim may or may not participate depending on substantive law to come. I mean, that's really what the substantive law here is, and the procedural rule needs to follow the substantive law. The real problem here is.
But what you don't want is something coming out that you think kind of assumes or indirectly establishes substantive law on this point.
Exactly, Your Honor. That's the concern. And the language may file petition, and then when it talks about the issue is the scope of the participation, that already assumes the participation will.
Of course, you know that if we issued this, if we adopted this rule, be an opinion with it, and an opinion could say this does not decide any substantive matter related to whether or not such a right may be successfully invoked, whether such a right exists or may be successfully invoked.
Your Honor, I have seen those caveats and opinions from this court for years. And then I have seen the DCA opinions saying Florida Supreme Court is presumed to enact or be constitutional and be correct. And this is true in every jury instruction case. I mean, it's an amazing dichotomy in the Florida law. I understand that you can say that in your opinion. Sometimes the deference to this court from the DCAs, I think, is correct, but it's maybe too much when you've said don't defer and they still defer, and they do. That's our real concern, is that any language that looks like this court is leaning one way or the other. And the real issue for us is, I think when you have a real case in controversy with real facts and real parties, this will be much clearer as to whether the rule applies or not. Most appeals, most criminal appeals, there's no release issues involved. It's just a request for a new trial. It doesn't really fall under the provisions of Article 1, Section 16. There is one provision that talks about appeals, and it doesn't provide for participation, it provides for expediency. So there's the drafters of this constitutional language clearly thought about appeals. They knew about how to include language for appeals, and they deliberately didn't. I mean, there's a lot of, and all of these arguments will only become clear in the context of a very specific case. Is this case involving the possibility of release, of pretrial release, or pretrial or other release is the language from the Constitution? That all of that can only happen, I believe, in the substantive law. I believe that this is premature. The suggestion that, of course, victims could do this through the amicus procedure that currently exists. There wouldn't even be a need for another procedure. It already exists under the rules, and that could then allow the development of this law. And Mr. Upson's absolutely correct. There are attorneys marketing themselves as victims' rights attorneys. This is a burgeoning area of law. And I am sure that these such motions and petitions, we're seeing them in the trial courts. I'm sure we will see them in the appellate courts, and then we can decide on a case-by-case basis that will then allow it to flesh out. But we have a procedure already in place.
So, Mr. Morrison,
sorry.
what you're saying then is that we're going to need to wait. What you're suggesting is that we wait until, say, a month from now, in a particular case come before us, let's say a death penalty case or robbery case or rape case before us, that a victim file a motion demanding pursuant to the Constitution to appear before us, and only at that time do we deal with it?
I think at that time you'll have specific facts and cases in controversy, and at that time you'll be able to say, is this case fall under the language of Marsy's law? Does this involve pretrial or other release? Or is this case just in a death penalty case? I know of no situation where there's a release from a death penalty. It's a new trial or new sentencing or something to that extent.
Well, people do get discharged.
Yes.
There are cases where people get discharged.
Your Honor, it's been a while. I don't recall
Well,
one. I must
I
confess
can remember some not that long ago.
Your Honor does more. I do not do death penalty work, and so Your Honor's recollection and knowledge is far superior to mine. I simply don't.
Counsel,
yeah.
I'm sorry to interrupt you. Are your
Yes, sir.
concerns allayed or eliminated if subsection C drops away altogether?
That helps, Your Honor. I'm a little concerned about subsection B, which seems to allow the victim to place things in the record on appeal, which may not be appropriate. We have lesser concerns about that, but at that point, candidly, Your Honor, I'm not sure what we're doing. This is very premature. If subsection C drops away, what does this rule do? It repeats the constitutional definition, and it says, shall include any filing by a victim or authorized filer, which the rule has always been in appeals that the appellant is the captain of their own ship. They send forth the record on appeal, and then if the appellee has something else they think should be included, they send that forward. There's a process for this, and I can't see why that process would not work in this context. Again, if for some reason in a criminal case, defendants are always the appellant. If the state does not include appropriate statements, I guess as an amicus, a victim could come in and say, you really should also look at this, probably, as Justice Polson suggested, extra record, inappropriate material, and the court can make a decision on that. But without section C, I'm not sure what this rule does, Your Honor. I think that really highlights the premature nature
So how does section C though go beyond? So in the Constitution itself, in section 16C, it talks about the victim or their lawyer being able to assert and seek enforcement of the rights enumerated in this section, blah, 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 in any trial or appellate court as a matter of right. I mean, other than just saying you basically do that by filing a motion and then to be determined what your rights might be, since we already have that provision in the Constitution, is it doing harm? I mean, what's the downside of having what's proposed?
The downside is exactly as Justice Kennedy and I's conversation indicated, that
I wasn't agreeing with you. Don't get. Don't.
I didn't take
your response to my comment.
Yes, I did not take your comments as agreeing. I'm referring to the conversation, and in that conversation, the concern is the court promulgates language suggesting that it agrees that there is a right to participate on any specific situation. Right.
Do you have a problem though in principle if we already have in the Constitution that you can assert your rights, it refers to appellate courts, it says that you can do so as a matter of right. Do you have a problem in principle with the rules telling people, without commenting on sort of what the merits of their request might be, how you mechanically go about asserting your rights under 16C?
Under 16C, at least both the proposed and the original versions, essentially the language indicates that the victims are part of this proceeding, at least a quasi-party, if not a party, and that is inappropriate. The language Your Honor referred to says that you can assert the rights earlier in the constitutional amendment. The question is, does that apply? Does that apply in a criminal appeal? Is there any right in a criminal appeal where the issue isn't release, but the issue is new trial? Is that that is all substantive law that needs to be worked out on a case-by-case basis, and a broad statement by this court that you may file this, and then especially under the new proposal, and then it's a question of proposed scope, really gets this exactly backwards. It says we're going to decide that you can file, that's the substantive issue, and the proposed scope of what you're going to be able to do, all that procedure is going to be left up to each and every DCA panel, maybe the DCAs as a whole, and each DCA will decide something differently. That really, I think that sort of highlights the fundamental problem with these rules. Without the substantive law, this just doesn't work. Fundamentally, this just is not working.
Mr. Morrison, I'm wondering, I've heard your reason why you thought it was problematic to do what I sort of view as perhaps an interim rule, because it seems to me that if the substantive issues determine that victims don't have this right, then the rule would go away. We'd repeal it to be interim in that respect. If we determine that they do have that right, once we get some experience with it, we probably would want to amend it to put some other procedures in. So, I mean, it's an interim rule. I don't know that we've done that before, but I also don't see a problem and do see the advantage of telling people just do this until we figure it out. I have a high degree of confidence that we can write an opinion that explains that this is not deciding the substantive issue. And I also have a high degree of confidence that our DCA judges will be able to read that opinion and understand that we haven't decided the substantive issue. So other than that concern that this will indicate that the substantive issue has been decided, is there any other reason why this would be a bad idea?
If the court wanted to do that, then it really need to be sent back to the committee. There would have to be an entire procedure.
I didn't follow what you said about sending it back to the committee.
Oh, I'm sorry. Let me, in the 15 seconds.
Yeah, I'll give you a little more time.
If there was to be an interim rule and specifically reserving the issue of any substance, then the rule would need to say, essentially, the defendant's usually the defendants or the state also has an opportunity to respond as to whether there is a right under the Constitution and there would be a whole separate issue of litigation of that, and that would require a whole nother procedural. There's a motion. There is a right to respond so that it's clear within the rule.
But I mean, isn't it kind of either understood or there's some general provision in the rules that if one party files an motion, that the response can be filed by the people that have an adverse position in the case?
I think it would need to be clear that once the motion only triggers the issue of whether there is a substantive right. That's and anything short of that, and particularly the language here, the scope of the victim's participation, scope is a real problem because that implies procedure, when, how, not whether, which is the sub. And there would have to be some sort of the committee.
What if it said nature? What if it said nature and scope? I mean, the word proposed is in there.
The word proposed is in there. Yes, indeed. That seems to be limiting the question to the how, when, where, but not the whether they can participate at all, whether there's any current constitutional right in this particular situation at all. And if I look, I have not run this by the elected public defenders because this simply is a proposal that was not before us, was not promulgated. But if there was to be some sort of interim rule with some sort of procedure like that, there would have to be a clear procedure where it's clear that that triggers the substantive decision, not something else. There's a number of ways to do that, but I think that requires more drafting.
If you're over your time, go ahead and sum up in about 30 seconds, if you would.
Your Honor, I think I have. This is substantive. This is not procedural. This court should wait. That would be the recommendation of the FPDA. Thank you so much for your time and attention to this matter.
Okay, thank you. Mr. Upson.
Thank you, Chief Justice. I don't want to do this. You're hungry. To answer your question, because I had the luxury of not having to participate at the time, it's 9300A that provides that with one exception, a party has 15 days within service of a motion to file a response. So we've already got a rule to file a response. I didn't have enough time to look up what that one exception was. It was 9420.
It's probably not the Victims' Rights Amendment.
I'm not familiar in my practice. I'm not familiar with 9420, so I didn't scroll that far. But fundamentally, and I think because the reply to the response, I believe is so well written. I think if nothing else, we've identified that there are a lot of issues here, and there are a lot of concerns within the committee as well. I think it comes down from the position of the majority of the committee, and I'm going to go in reverse order. 16B6G in post-conviction proceedings that says the victims have the right to be informed of and to participate. That's got to include 9140 and 9141. That's got to include appeals. Less clear, but still dispositively clear, 16B6B, and that catch-all, any proceeding during which a right of the victim is implicated. I think clearly the amendment gave victims the right to participate to some extent in appeals. They didn't say any enumerated proceeding, any of these things we just listed. It said any proceeding. So then the question becomes, are appeals a situation where the rights of the victim become implicated? I don't think this is a situation where the committee has put the cart before the horse, and we need to, I don't think it's a substantive issue. I think the argument is nonsensical if you think the rights of the victim aren't implicated on appeal. And the hypothetical I will give in 3 seconds is, I think we all agree the victim has a right to attend the defendant's sentencing. The defendant is sentenced. The defendant is remanded. 2 years later, the victim receives a notice of a status conference in the trial court. What is this? The victim goes to court. The circuit court judge brings the defendant out and says, well, I've got this DCA opinion that says that we violated Speedy. They have vacated your judgment and sentence and you are discharged. Good day, sir. Go about your life. The victim in that situation has absolutely no idea what's happened in the interim. Unless we agree any proceeding during which the right of a victim is implicated includes that entire appellate process. The majority of the committee continues to maintain, if you agree that Section 16 doesn't apply to appellate proceedings, then never mind, there's nothing to see here. But if it grants victims the rights that we read that it grants the victims to rights, we overwhelmingly believe having some rule, even a vague rule, to provide some guidance is better than no rule at all.
So are you saying you would object to court commentary that sort of punted on the substance, as opposed to just doing something in the opinion that may get lost in the midst of whatever?
I'm sorry, Justin.
Putting something in, I mean, it seems like the conversation earlier was going to, you know, having us say something. You obviously have a view on the substantive issues and a view on the rule. It seems like there's another way of looking at the rule that would say, you know, say that it kind of punts on the nature of the substantive rights. Would you have a problem with court commentary to the rule, as opposed to just saying it in the opinion? Court commentary that says, you know, the promulgation of this rule doesn't mean that, you know, we've determined what substantive rights to participate, you know, any victim might have in an appellate proceeding.
No problem with that at all. I think we'll all feel a lot better when we do have more guidance. So if it's some of the detail that was suggested earlier, because this court can write an opinion that fleshes this out right now, I don't think it's necessary. I think because this court can provide more substance doesn't make the proposed rule a substantive rule that needs to wait. But similarly, to directly answer the question that was asked, we wouldn't have any problem with the court saying implementation of this general rule in no way passes on the substance at this time. I think that memorializes the spirit of what we were trying to accomplish. We were trying to provide some framework with the awareness we're probably going to have to amend or.
You sort of confused me when you came back and said, but if you don't think we're right substantively, then you should just not adopt the rule. I mean, I think that's.
Well, it's kind of buried on the last page above the signatures and the response to recommendations, but the majority of the committee has already discussed if this court agrees with the commenters that no right to participate in appeals was created by the amendment.
I think the suggestion is shouldn't. We generally don't decide those substantive issues in rules cases. We want to wait and let some, I mean, so I wouldn't want to decide that here in this case, one way or the other. But I think Justice Kennedy and others were suggesting was that this, the way it's written, it doesn't assume a right of participation or what it involves, but the rule would give parties guidance as a point. They could file something and say, we want to file an amicus brief, and there could be no objection, and we just go on. Or they could file something and say, I want to designate something else from the record of appeal, and then the other side could object and say they don't have the right to do that under the Constitution, and then that would get litigated and decided. So, but I don't think, I personally wouldn't want to decide one way or the other whether the right exists. So I wouldn't want to agree or disagree with the majority. And if that's the case, you're saying we should just not adopt the rule if we don't agree or disagree?
Thank you for the opportunity, Justice, to explain. We believe that the rule as proposed, as revised, doesn't create any substance, but merely provides the procedural framework by which this can all be sorted out by the judiciary.
Okay.
I got hungry too, so.
All right. That sounds, unless you have something else to say, we've gone over a little bit here, but we thank you all for, or thank you both for your participation